Right, good evening, everyone. Welcome to this Commercial and Corporations National Practice Area event here in Melbourne and across the country. As a national court, it's fitting that this event is being conducted both in person and online at our registries around the country. I pay my respects to the traditional owners of the country on which all our participating registries are located and acknowledge their respective ancestors, elders and communities for their continuing stewardship of their traditional lands and waters and their commitment to preserving their laws and customs and their languages. My thanks to our excellent new team of national coordinating judges in this practice area, Justice Banks-Smith, who's based in WA but here with us tonight in Melbourne, Justice Derrington in Sydney, Justice Cheeseman, Derrington in Brisbane, Justice Cheeseman in Sydney and Justice Niskovchin here in Melbourne, who is our most recent recruit as a national coordinating judge in this area. My thanks also to our two national coordinating registrars who are with us here in Melbourne, Tim Luxton and Jacinta Ellis. This event is the court putting into action the profession's request for regular engagement with the court on a practice by practice area basis. My colleagues will be presenting on three topics of key relevance to the way that our commercial and corporations work is undertaken. Taking the 6 sub-areas together, the commercial and corporations practice area is by far the court's busiest, responsible for between 65 and 70% of the federal court's total filings in 2024. For comparison, the next biggest area is migration at 12%. So that difference demonstrates the importance of this practice area to our work. It is also a practice area that contains some of the court's most legally significant and high-profile work at both trial and appellate level. So thank you to all the members of the profession here and interstate who have taken time out of your busy working days to come and join us, and we look forward to your contributions in person in each of the registries once we get to that part of the program. I'm going to hand over to my colleague Justice Cheeseman in Sydney, who's going to explain how the evening will run. Thank you.
Thank you, Chief Justice. For those of us gathered in Sydney, I pay my respects to the Gadigal people of the Eora Nation, whose country we're on. Our format for this evening is to do effectively a whistle-stop tour of the entry points for corporations matters in the Federal Court. We're going to have 3 short presentations, which will be the part of the presentation that's beamed around to each of the registries. I will cover urgent matters before the Commercial and Corporations Duty Judge. We'll then cross to Justice Niskovchin, who will address the regular corporations lists in the court, and then finally to Justice Banks-Smith, who will address corporations matters in the docket system. After we complete the 3 short presentations, we will drop the AV connection, and with the panel of judges sitting at the front, but also with the registrars that are attending in each of the locations, we'll have an in-person question and answer session, and then hopefully some of you will be able to stay to join us for refreshments and that dialogue can continue. So on behalf of the 4 national coordinating judges, I thank our colleagues for attending this evening. All right, to the first topic, urgent applications. Practitioners will be aware that the court is trialling a new duty judge regime. At the start of the 2025 court term, we began a new trial which involves 3 distinct geographical regions, and each of those regions is running a separate roster for urgent duty matters. The object of the trial is to seek to better manage the listing and determination of duty work in the context of the court's national court framework, but also the individual docket structure. The Chief Justice, in her meetings with the profession in each of the registries, actively seeks constructive feedback on the operation of the trial, and we've already modified one aspect of the new arrangements as a result of feedback received from urgent migration matters. So the court is interested in receiving constructive feedback during the trial. We will continue to trim our sails based on constructive feedback as we go. So why have we introduced this? The aim is to develop a duty regime which results in a more even distribution of duty work across all the judges in all the registries, while ensuring that sufficient resources are available to determine genuinely urgent applications quickly and by the most efficient means appropriate in the circumstances of the particular application. The duty judge system kicks in when a matter or part of a matter is assessed to require an urgent hearing or urgent case management, and a docket judge that has the matter is either genuinely not available or has not yet been allocated. Duty work is important to the work of the court. Almost 2/3 of duty filings are in the C&C national practice area. Traditionally, we've managed a peak period. The last week of court term in December tends to be fast and furious in duty. When we were looking at this trial, there was a suggestion that there might be a second peak in around the pre-Easter period. So this year, for the first time, we sat 2 duty judges in that week, and it proved to be busy relative to the other weeks around it. It's too early to say whether or not there is truly a second peak there, or whether it was just as a result of the magnetism of Justice Owens, who was sitting in the C&C duty list that week with Justice Markovic and myself. The 3 regions are briefly Region 1, New South Wales and the ACT. In that region, we run 2 streams, a general duty stream and a C&C duty stream. Likewise, in Region 2, comprised of Victoria, Queensland and Tasmania, also divided into 2 streams. That reflects the volume of work in those registries divided into those regions. Region 3 is comprised of West Australia, South Australia and the Northern Territory, because of the lesser volume of duty matters in that region, and also the lesser number of judges available to sit as duty judges. That's a combined stream. So general and C&C run as one stream. The way in which the trial will operate was announced in a notice to the profession that was published on the 31st of January this year. You can still find that on the court's website. It includes an email address if you have feedback on the trial. The 2 important pieces of work that practitioners should take time to familiarise themselves before they bring an urgent duty application were launched to coincide with the commencement of the trial. They are the new duty practice note and the certificate of urgency. The duty practice note is a reference point for both legal practitioners but also litigants in person. It formalises some aspects of the court's existing practice in relation to duty applications, and it also introduces a requirement that a certificate of urgency must be provided in support of the duty application. The duty practice note should be the first port of call for all applicants in duty matters. From that duty practice note, you will radiate out to specific parts of the court's practice notes that are part of the well-known armoury for a duty application. The practice notes relating to freezing orders, the practice notices relating to search orders, the endorsement practice note. So we've tried to collect in one point a hyperlinked version of, if you're trying to deal with something urgent and you're working out what to do, you go to the duty practice note, and you radiate from there to other practice notes that you should be aware of. The duty practice note provides guidance for the entire life cycle of a duty event that can span across multiple duty judge periods, sometimes consecutively, sometimes at various intervals in the life of a proceeding as a whole. After the urgent aspect of the application has been heard and determined, if the proceeding is ongoing, the proceeding will then be allocated by the National Operations Registry to a docket judge in accordance with usual allocation principles, or in some cases it might be referred into the corporations list, about which you'll hear more from Justice Neskovchin. Turning to the Certificate of Urgency, the Certificate of Urgency has been designed to act as a checklist or a roadmap, both for the person bringing the application, but also for the duty judge hearing the application. It steps the applicant through the information that might previously have been provided in the first call to the duty judge's associate or the first email to the duty judge's associate. And it also covers additional requirements that have been introduced in the practice note. The certificate is to be completed prior to contacting the court to ensure all the relevant information is available and that the applicant uses the correct initial point of contact in trying to have their urgent matter listed before a judge on an urgent basis. That said, obviously, a practical approach will be taken by the court, and indeed the court encourages a practical approach from practitioners. So in some instances, a duty judge may dispense with the requirement for a certificate of urgency if the circumstances truly warrant it. But the fact that a certificate is required shouldn't stop the old-fashioned courtesy that the profession usually observed of making a call or sending an email to the duty judge's chambers that is effectively, depending on the level of experience and or stressed by the person communicating, either a heads-up email or a caps lock bold incoming type of email. So if you haven't got everything ready to complete the certificate of urgency, still think about the logistics and the practicalities. Let the duty judge know that you're anticipating bringing an application broadly, something about it, but that you will provide the certificate of urgency as soon as you can. In the certificate of urgency, the applicant has to demonstrate that the application is genuinely urgent so that it warrants being heard by the duty judge. And at the end of the day, urgency lies in the eye of the duty judge and not on the applicant's say-so. So the certificate of urgency is important. We step through in the certificate of urgency how to work out, if you're in a two-stream region, how to work out whether you go to the general duty judge or whether you go to the C&C duty judge. And that calls on practitioners to have a think about the substantive relief sought and which of the national practice areas and sub-areas is most closely connected with that final relief. And then there's a list of, these are the ones that fall in general duty, these are the ones that fall in C&C duty. And on that basis, you certify which duty judge you're going to approach. So we really ask that practitioners are careful and considered in thinking about which duty judge to approach where there are two streams. Bearing in mind how much we're going to cover this evening, the key takeaways, and we'll come to other questions perhaps in relation to duty once we drop the live stream, but the key takeaways for practitioners, I think, are familiarise yourself now when you've got the luxury of time and you're not staring down the barrel of a duty application with the practice note, with the certificate of urgency. Take a practical, realistic and responsible approach to approaching the duty judge. Be conscious of your obligations if the application is brought ex parte. critically evaluate whether it should be brought ex parte. Is it closed court? Is suppression or confidentiality required? And if so, for how long and how precise should that protection be framed? Consider genuine urgency. What aspect is truly urgent? Is it just part of the matter? If so, delineate that part of the matter, and the rest can perhaps travel in a more orderly way through to a docket judge. Understand that time is limited for urgent applications. Being proactive in getting materials to the duty judge so that the duty judge has had an opportunity to read the materials and to list the matter for urgent hearing and deliver reasons if reasons are required really is a dance of two willing parties between the court and those bringing the duty applications. So I will now hand over to Justice Neskovshin to address the regular corporations lists.
Thank you, Justice Jasmine. Weekly corporations lists have been established in the New South Wales, Victorian, Queensland and West Australian registries. The weekly corporations list in the South Australian registry has ceased to operate due to insufficient filings to justify the list, a separate list at the moment, and corporations matters filed in that registry will be allocated to a docket judge in the usual way. The National Operations Registrar, with the assistance of the National Operations Team, determines whether a matter is suitable for allocation to the corporations list in the registries in which the lists operate. Corporations matters will usually be allocated to the corporations list if they're short matters, meaning matters with an estimated hearing time of up to 2 hours, and that are able to be determined on the first return date. If after entry into the list it becomes apparent that it is a longer matter, the first return date will generally be used to program the matter out for hearing, and the matter will then be allocated to a docket judge who will separately set the matter down for hearing on a date to be fixed by that judge. Where appropriate, matters will be referred to a registrar, and where matters are more urgent, they may be referred to the Commercial and Corporations Duty Judge. The notice to the profession of the 13th of November 2024 explains the allocation and listing procedures which apply to corporations matters filed in the weekly corporations lists. I don't propose to set out or to speak about the detail in the notice now, but essentially it works like this. The notice sets out the time and day of the week in which the list operates in the particular registry, and the time and day by which the application needs to be filed in order to be listed in the following week. As I said, please refer to the notice to the profession for more details. But the sorts of matters that tend to be allocated to the corporations list include applications for extensions of convening periods, applications for directions by a liquidator, administrator or receiver, applications for the appointment or removal of a receiver, particularly where companies in liquidation bear trustees. So essentially, they tend to be short matters where a court order is usually required, where matters are uncontested but not always, but particularly where all the necessary parties are present or they've been notified. The court considers that the corporations list is a very effective and efficient means of dealing with straightforward matters in a timely way. However, and this is a big however, for matters to be determined in the ordinary course in the corporations list, the court relies heavily on the parties and practitioners to be well prepared, to ensure that all materials are in order and that the requirements of the legislation, regulations and so on have been met. And so parties can be expected to be called upon by the court to give an assurance that the material is in order, the various requirements have been met, and if appropriate, whether there are additional considerations that need to be brought to the court's attention. So that was definitely a whistle-stop tour, and I'll now hand over to Justice Banks-Smith.
Thank you. I'm going to provide a general overarching introduction to commencing and steering corporations matters when they're allocated to a docket judge. So matters might be allocated after first being dealt with by a duty judge, but in most cases they're commenced in the traditional way by filing an originating process. If the party seeks relief under the Corporations Act, the ASIC Act or the Cross-Border Insolvency Act, then that claim will fall within our corporations and corporate insolvency subgroup. If you're interested in the mysteries behind the scenes, judges don't control the allocation process, and there are all kinds of sound reasons why that is the case. It avoids judge shopping, it assists with workflow, and it creates an environment where different judges can bring new ideas as to how things might be understood or dealt with, and so on. But all registries of the court have dedicated corporations judges with expertise in corporations matters. The variety of work undertaken by this subgroup is enormous, and it creates opportunities for lawyers to really shape how a matter might be run, and it also creates advocacy opportunities at different levels, and I'll come back to this. First, I'm going to touch on some essential reading material. And many of you will be familiar with these, but we have a cross-section of people here today, which is fantastic, and so I thought I would just provide a quick rundown. First, there is the overarching central practice note, CPN1, with its focus on case management. But then more particularly for us tonight, there is the Commercial and Corporations Practice Note, or CNC1. This note emphasises that the court will facilitate the use of a range of mechanisms for the commencement of proceedings and case management. It's tailored to address commercial disputes so that proceedings are commenced and managed in the manner best suited to the character and needs of each case. For example, the practice note refers to 3 methods of commencing corporations proceedings. It can be done by an originating process supported by a statement of claim. It can be done by an originating process with a concise statement in narrative form, or it can be done by an originating process supported by affidavit. So right at the beginning, before you even commence an application, you should take the time to carefully consider which is the best of those methods, having regard to the type of application you're bringing. I think it's fair to say that by far the majority of corporations matters proceed by way of originating process supported by affidavit. But the concise statement approach is often used, particularly in ASIC matters, at least as a starting point in disclosing the facts important to proving a claim. There's no question that some matters are still best dealt with by pleading them out. These are things that legal representatives need to think about carefully. In addition, the CNC practice note has schedules, and tucked away in those schedules are very important things. Schedule 1 deals with the corporations list, which Justice Moskovchin has just spoken about, but there's more in it that is also important. If you keep working your way through that schedule, you will find, for example, notes that guide how oppression claims are to be dealt with. And I'll come back to that. Turning from practice notes to rules, the Federal Court rules apply generally in corporations matters, but the Federal Court corporations rules exist, and some people are not even aware that they are there. They're quite important. They apply specifically. They prescribe their own forms for commencing proceedings. There are some particular procedural oddities about the Federal Court corporations rules that it is worth knowing about. For example, for originating processes, the person seeking relief is a plaintiff, and the person against whom the relief is sought is a defendant. The corporations rules do not use the language of applicant and respondent. I can't tell you why. I can just tell you that that's what it says. And as an aside, we're always quite impressed when we get papers that actually refer to plaintiffs and defendants because we think, oh, somebody's had a look at the Federal Court corporations rules. The rules also provide that notice of certain applications has to be given to ASIC, and there are also particular rules relating to examinations, winding up, remuneration of insolvency practitioners, schemes, and so on. In Schedule 2 to those rules, there is a list of powers under the Corporations Act that might be exercised by a registrar. You will know that registrars routinely deal with winding up matters, and they also have an important broader role in this subgroup. But if you're interested in what powers they actually have, that is the place to look, Schedule 2. So there are things tucked away in those practice notes and rules and schedules that are actually quite important and even useful. One of the best things about doing this kind of work, I think, is the scope for real input and in a sense, advocacy from the profession as to how a matter might be managed. I'm going to refer to some examples now that show how some different types of corporations matters might be managed with a docket judge. There is no doubt that insolvency regimes are the gift that keeps on giving in terms of applications to court. There are numerous examples of appointments that have led to rolling applications. For example, the administration of Virgin Australia that was docketed to Justice Middleton and resulted in at least 9 separate published judgments. There was initially the common application for an extension of the convening period for a meeting of creditors, but this was followed by a number of applications, some of which in turn sought layers of relief. Joinder, extensions of time, curative directions, directions about the conduct of meetings, relief from personal liability, orders authorising the use of software to facilitate the adjudication of claims of numerous creditors, whether alternative deeds of company arrangements should be taken to the creditors, court consents to share transfers, and so on. There are many similar examples across the country of these types of administrations before docketed judges, and where the judge has the benefit of layers of accrued knowledge from all of those various hearings, and the parties have the benefit that it is not necessary to go over again and again foundational matters relevant to the relief sought each time they need seek additional orders from the court. Parties in those kinds of insolvency matters can approach the chambers of the docket judge, including on an urgent basis, and there is a level of continuity across the period of the administration. This enhances efficiency for everyone. There is also in this sphere the opportunity for the parties to think laterally about the relief they seek and come to the court with their own ideas. The practical developments in the last 5 years in relation to virtual meetings, virtual notices, portals for creditors and dispensation with certain outmoded forms of communications are all products of such thinking, but proactive approaches can go deeper and will always be welcome. Another area where practitioners are encouraged to be proactive are so-called mothership proceedings, where, for example, a liquidator brings claims against a number of different defendants for separate voidable transactions. What are the common themes? How can they be dealt with? Can the date of insolvency be assessed once and for all by a referee, saving the need for separate determinations in separate actions? These are the things to think about. A docket judge is likely to welcome and embrace those kinds of suggestions. So do not shy away from novel ideas. The continuity of your access to a docket judge through case management hearings provides a forum for dialogue about these sorts of matters. I want to briefly say something about oral advocacy in this area. Many, but by no means all, corporations' applications are straightforward. They apply well-recognised principles and are heard in court on the basis of affidavit evidence without cross-examination. They therefore provide a great opportunity for junior barristers to get on their feet in court and develop confidence in making oral submissions. They are a learning platform, and we encourage junior practitioners to embrace the opportunity to undertake this type of work. And so to come back to oppression matters, these are more common than you might think. They are often intertwined with the breakdown of close personal relationships, and the fact that the schedule, to which I referred expressly, refers to oppression actions is no accident. It reflects careful thought about the steps that might see those kinds of quite highly personal actions efficiently resolved before positions become too entrenched. So the filing of affidavits in the early stages is limited. Parties are quickly directed to mediation at the first case management hearing generally. And steps for valuing shares and those sorts of issues that need to be addressed can be discussed early. So again, case management is central to any early disposition, and the ideas and contributions of counsel will be welcome. I'm not going to touch on mega litigation. It is also part of what we do in this subgroup. You know what Section 37N of the Federal Court Act requires, and I won't repeat it about the onus on lawyers and parties. But bear in mind that a docket judge has a broad case management discretion. So again, think about in mega litigation the issues that can be hived off. How can disclosure and discovery obligations be fairly contained? Which issues might be referred to in mediation, even if as a whole there is no apparent scope for settlement? Are there bite-sized pieces that might be resolved? Please come to case management hearings in these big pieces of litigation, having thought about these things, and give us your ideas on how issues can be distilled to a human scale. And now we welcome your questions and feedback on any of the things we've discussed today. And I think the video link is going to terminate, but we look forward to those conversations. Thank you.